Good morning, respected Director, Professor Dr. Shashikala Gurpur ma'am, our distinguished guest speaker for the day, Professor Dr. Yarik Kryvoi, esteemed directors and deputy directors of all three sister law schools, Symbiosis Law School Noida, Symbiosis Law School Hyderabad, and Symbiosis Law School Nagpur, esteemed faculty members, and my dear fellow students. I am Anika Tony, a second year BBA LLB student, and it gives me great pleasure to welcome you all to today's guest lecture cum faculty development program hosted by the Symbiosis Law School, Pune. The topic for today's discussion is 7 key legal skills for success as a lawyer and how to master them, a subject both timely and relevant for every aspiring lawyer in today's fast changing world. These skills lie at the core of professional growth and effective practice, making this theme of particular importance for students and faculty alike. It is my honor and privilege to introduce our director, Professor Dr. Shashikala Gurpur ma'am, Fulbright Scholar, Director of Symbiosis Law School, Pune, Dean Faculty of Law, Symbiosis International Deemed University, to a distinguished guest speaker for the day, Professor Dr. Yarik Kryvoi, Director of the Investment Treaty Forum and Senior Fellow in International Economic Law at the British Institute of International and Comparative Law. Dr. Shashikala Gurpur ma'am is also the Jean Monnet Chair Professor in EU Climate Justice Law, Governance, Management and Policy. She has a unique distinction of being appointed as Honorary Professor, Irish Human Rights Centre and School of Law, University of Galway, Ireland. With over 33 years of teaching experience, she has shared her knowledge and expertise at prominent institutions like NLSIO Bangalore, SDM Law College Bangalore, and the University College Cork, Ireland. Ma'am has over 108 publications, 4 co-authored books, and 17 book chapters to her credit. She is also the former member of the Law Commission of India and listed as one of the 100 legal luminaries of India by LexisNexis. Dr. Gurpur ma'am has also been the member of sector-specific group for digital and creative economy in the Ministry of Education, Government of India, and member of Task Force on Governance of Higher Education by State Government of Karnataka. She is also associated with the Law and Policy Journal in Dublin and contributes to the Curriculum Development Committee of the Bar Council of India and the Academic Council of the National Judicial Academy. In addition to her pioneering work in EU legal studies in India, Ma'am had been the project leader for 4 Erasmus Plus projects and is currently heading the Spark project of the Government of India on behalf of Symbiosis International University. It is now my honor and privilege to invite Professor Dr. Shashikala Gurpur ma'am to kindly deliver the welcome address.
Very good morning, Professor Yarik Kryvoi, my Deputy Director, Dr. Mohanty on the dais, all the faculty members of the dais, and most of all, dear students. A very good morning and a warm welcome to each and every one of you. Today's occasion is very special in many ways. First of all, Professor Yarik was introduced by none other than our own star alumna, Akash Banial. They both met in Oxford, and then Akash thought that he should be introduced to you all. Secondly, it's very special because it's a professor talking about skills. Ours is the only law school in the country which has a very structured skills program alongside the normal knowledge and ethics kind of courses. Although majority of the courses for undergraduates is for knowledge, there is a substantial number of courses which go for ethics. Although ethics also has not been very focused in the Indian legal curricula, except one course which are council mandates. So skills courses, we have developed about 30 skills courses. We were very ambitious to start a unique legal skills center because I was involved with the Bar Council's education committee, and we thought that there is a large deficit and also a lot of reports coming about how translation from law graduation to the courtroom or any kind of avenue sees that there is a huge gap in terms of this readiness to the career or the profession. So in 2019, Dr. Menon, who is no more with us now, he spoke about how lawyering skills have to be integrated into the classroom. Unlike UK or USA, where those who are going in the profession track have the choices of being solicitors and qualifying in the attorney exam, in India, everybody who graduates in law is eligible to be an attorney after passing the formal examination. And in Symbiosis, the result has been 100% ever since the All India Bar exam started. And I have large number of students who, due to last year Supreme Court's decision, could appear for this qualifying exam in the penultimate year in both the 5-year program and 3-year program. Unlike Harvard, we have our law graduation after +2, after higher secondary, and another stream goes with graduates. We have a small number of postgraduate 3-year LLB program, which is comparable to your JD, whereas here we mostly have 5-year program because we wanted to put it on equal footing with the medical education in India, which starts after the 12th standard, unlike in US where any graduate can enter medicine. So there are a lot of parallels between us and the British education. But the most important unique feature that we have, like most of the Commonwealth countries, is that our graduates can directly enter the bar. They are qualified to enter the bar. Now, that makes us to think and rethink, because the senior lawyers who are at the bar, who always look at our fresh graduates as some who need to be taught, who need to be trained, and they don't have the patience. So Bar Council introduced a concept called internship. So 5 internships are mandatory, and no lawyer takes them in their office after their 3rd year, which means it leaves them only 2 internships ideally. But in Symbiosis Law School, Pune, we experimented with this idea of skilling students, because both the Chartered Accountants organization, Company Secretaries organization, and others said that 85% of the success is based on skills. And 85% of what matters in the profession is skills. So we started introducing the skills from the first year in terms of generic research skills and generic thinking like lawyer kind of skills, where an American attorney comes here and trains our students, because America has a very rich scientific skills approach for over last 150 years, whereas in the UK it is just emerging. We were much earlier than the UK also in terms of this. Secondly, we have these curricula very well developed in terms of Berkeley factors, in terms of Australian legal skills expressions, Canadian, CALD. So all of them we put together. So from the first year onwards, in a gradual manner, we introduce these legal skills, which they also reflect during their internship, and they bring back their internship report, which is in the first year tested with the service learning. And after that, it is tested in terms of a cumulative grading in their final year for the 5-year course. For the 3-year course also, we have a semblance of this in a very concise manner. So this is what I have to tell you, which is a prelude to his address as well. In a way, it connects the 2 worlds, because we have to bridge the knowledge when it is transnational knowledge. Now, my own experience has been with our students. When we introduced the skills, we were very ambitious that our students have to stand out in the market. As such, the history of this law school, in last more than 15 years, we have introduced our own entrance exam, which is different from the national entrance exam for national law schools. Our numbers are almost 50% of those numbers, but we are only having 4 law schools, whereas they have to divide them between 28 law schools. So our law schools on the whole solicit about 20,000 to 25,000 applications. And Symbiosis Law School Pune is the first preference for all those 25, and only 300 used to qualify. This year we increased our numbers due to the market demand to about 450, and next year it's going to touch 600. Still, there is so much of competition, and we get filled by the first list. Very little remains for the second and the third list in terms of category affirmative action related candidates. So that ensures that the best skilled students whom we also test by personal interview find their place in this law school. So they're already ready. They have all those trappings of success in them. And then we start developing them, and they also take a lot of interest. There's an ecosystem of that, more than competitiveness, cooperation, where they have their own leadership team of advisory board, their various cells where they hone their skills and application side. Now, skills classes are ideally run in combination with invited guests, along with internal faculty monitoring the adherence or compliance with the curriculum that has been developed very carefully by a number of stakeholders who involve in a curriculum development committee. So I think this in a way introduces the whole idea to you also. all the students, and I mean, in a way, where you stand in terms of the larger milieu of law students in the world and particularly in India. And secondly, why we have skills courses and you have to take them seriously, because a professor like Professor Yarik has taken this concept to bring to the students, which means that it is a globally discussed theme and globally relevant theme. A very warm welcome to you once again, and thank you very much for making time for our students, and welcome one and all.
Thank you, ma'am, for your inspiring words. I now request Professor Dr. Shashikala Gurpur, ma'am, to felicitate our distinguished guest, Professor Dr. Yarik Kryvoi. Thank you, ma'am. Thank you, sir. To give a glimpse of how our university started and its ethos, we would now like to present before our esteemed guest what our university is and what it stands for through a film. I now request the IT department to kindly play the SIU film for our esteemed guest.
This is the story of a man who dared to dream and persevered to make his dream come true. The story of a visionary Indian who thought differently and has made enormous difference to the lives of thousands of students from all over the world. The story of Dr. Shantaram Balwant Mujumdar, the founder of Symbiosis. It began when Dr. Mujumdar, the rector of the boys' hostel at Pune's historic Ferguson College, was spending a quiet afternoon in his quarters. All students from India had left for their Diwali vacation. Only students from other countries had stayed back. Suddenly, Dr. Mujumdar's attention was drawn by the sight of a girl student. She was standing under a window of the boys' hostel, stealthily passing a small parcel to a boy inside. Suspecting mischief, Dr. Mujumdar went to the room to investigate. What he saw there left him disturbed and distressed. The girl had gone there to provide food to a Mauritian boy suffering from jaundice. The incident left a deep impact on Dr. Mujumdar's mind and a void in his heart. He was so moved by the experience that he resolved to improve the plight of foreign students studying in India. Symbiosis was thus born in 1971 from the seed of a dream sown by its founder, Dr. Mujumdar. His dream was to create an educational institute where, in his own words, students from all over the world would live, study, eat and play together in an atmosphere of peace, harmony, mutual respect and acceptance of cultural diversity. An institute from where foreign students would return to their countries as friends and ambassadors of our nation. Over time, Symbiosis has come to dwell not just within the walls of its many institutes. A world-renowned multicultural, multilingual and multidisciplinary educational institution, Symbiosis now has state-of-the-art campuses in Pune, Bengaluru, Noida, Nashik, Hyderabad and Nagpur. Symbiosis International University has also established a presence in Dubai, offering several specialized academic programs powered by highly qualified faculty. The university has multiple institutions in diverse disciplines of study, including law, management, computer studies, medical and health sciences, media and communication, humanities and social sciences, engineering, architecture and design. The university is at the forefront of research in diverse areas such as advanced legal studies, waste resource management, stem cell research, nanoscience and nanotechnology, medical image analysis, behavioral studies, applied artificial intelligence, entrepreneurship and innovation, media and creative industries, climate change and sustainability, and Ambedkar studies. Its network of more than 300,000 alumni worldwide, including over 1,000 alumni in the UAE, provides valuable support for internships and placements. In March 2022, on the proud occasion of the Golden Jubilee of Symbiosis, the Honorable Prime Minister of India, Shri Narendra Modi, inaugurated Symbiosis Arogyatham.
50 years ago, the idea germinated in my mind to promote friendship and understanding between foreign and Indian students and thereby promote international understanding. Today, we are celebrating Golden Jubilee of this golden idea.
कि 50 साल की आपके पास एक ऐसी पूंजी है, अनुभव की पूंजी है, अनेक एक्सपेरिमेंट करते करते आप यहाँ पहुंचे हैं। एक खजाना है आपके पास, ये खजाना भी देश के काम आएगा। बहुत बहुत धन्यवाद, बहुत बहुत शुभकामनाएं।
Symbiosis International University is truly internationalizing education, empowering every student to become a catalyst for change, a beacon of hope, and a force for a better world. For Symbiosis International University, the world was, is, and will always be its family. Vasudhaiva Kutumbakam.
It is my privilege to introduce our guest speaker for the day, Professor Dr. Yarik Kryvoi. Professor Kryvoi is a London-based lawyer, academic, and policy advisor, specializing in international and comparative law. He holds an LL.M. from the Harvard Law School and a PhD from University College London. At present, he serves as Director of Investment Treaty Forum and Senior Fellow in International Economic Law at the British Institute of International and Comparative Law, London. He is also of counsel at Karen Harrison and co-director of the Arbitration Lab. As an academic, he has taught in Europe, the US, and Asia, and authored influential books and reports, including Educating Lawyers in the Digital Age, From Theory to Practice, as well as works on arbitration, investment law, sanctions, corruption, and legal reform. He is also a trusted advisor to governments and international organizations, contributing to reforms in rule of law, economic crime, and dispute resolution. His expertise is recognized globally, and his guidance today will be of immense value to us. Ladies and gentlemen, please join me in warmly welcoming Professor Dr. Yarik Kryvoi to deliver his lecture on 7 key legal skills for success as a lawyer and how to master them.
Good morning, and thank you very much for this kind introduction. Professor Gurpur, colleagues, dear students, it's my pleasure to be in Pune for the first time, and I'm truly impressed by the university, by the level of organization, by the level of those students whom I already met. I should say it's a bit unusual for me to receive a gift before I give a talk. So what if you will be disappointed? Then I guess you will need to get back this gift from me, but I hope you will not be disappointed. I will talk first a little bit about my own background, why I decided to write a book and research the issue of legal skills and how to deliver legal skills in legal education. And I will talk about some education theories, and then at the end, I will talk about 7 specific legal skills which lawyers, according to my research, need to develop. And that will be very useful both for students and also for professors. and I will also give some recommendations about how to deliver those skills, how these skills can be taught in the law school environment. Although I've been living in the UK for the last almost 20 years, I was actually born in Belarus, and it's a country in Eastern Europe. And I did my first law degree in Russia, where the law degree was a 5-year law degree. In a way, as I understand, some of you may also follow a 5-year long degree. And this law degree is different from law degrees which you get in common law jurisdictions such as England or the United States. And I was not content with just getting one law degree, and I decided that I needed to study in other countries. So I ended up studying law in 5 different countries, in Belarus, my home country, in Russia, in the Netherlands, and in England, and in the United States. And everywhere I was exposed to different teaching styles, different languages in which subjects were taught, and also different emphasis, both on knowledge of law and on skills which were delivered at those universities. Not only I studied law in those countries, I also practiced law in several countries. So I studied in Russia, then I spent a few years practicing law in Washington, D.C., and I also practiced law in London, first full-time, and then more as a consultant part-time, on a part-time basis. In addition, I have experience teaching law, not only in the former Soviet Union countries and in the UK. I've been a full-time law professor, and until I think 5 years ago, I moved to the British Institute of International Comparative Law. So I had an opportunity to teach in the UK, in Belarus, in Russia, in the United States, in Japan, and also in Sri Lanka. So probably Sri Lanka is the closest geographically to India of places where I taught. And my university where I used to teach had a joint degree program with an institution in Sri Lanka. So I would go every year, twice a year, to Sri Lanka to introduce the courses and to cooperate with local tutors who were delivering those courses. After practicing law for a number of years in various jurisdictions, teaching law, I moved to work at the British Institute of International Comparative Law, which is essentially a think tank working on legal issues, on law reform issues, primarily on international law and comparative law. That allows me to work with various governments, with various law firms, and it's also a good position to compare how law is taught and practiced in various jurisdictions. So this is about my background. And as I was teaching law, practicing law, and studying law in various countries, I was always curious about trying to understand why there is a gap which traditionally exists between legal education and legal practice. Why lawyers in most countries cannot straightly move from learning law into practicing law. Even if they do, they still need quite a bit of education at their workplace to actually be competent lawyers, to be in control of what they are doing with little supervision. I also understood that legal academics usually do not have very good familiarity with theory of education. So there are those people who study theory of education and those people who study law. And theory of education is not really well known among legal academics, which is not unusual because they don't study it at law schools most of the time. And so this deep divide between legal education and legal practice was one thing. Another thing, I was trying to understand how to tackle an international demand for learning at scale. There are many lawyers from and recent graduates from foreign countries who come to the UK to study law. I was one of them. I also studied in the US. And I was wondering whether there was a way to deliver legal education cheaper and at scale to a bigger number of people. And of course, for many people, getting good quality legal education can be difficult because of its high cost and because of various barriers which exist, not only economic barriers, but for example, legal barriers, which people have to overcome to go to study in other countries. So I thought that online legal education, technology in general, could help to divide this gap and to address some of these problems. Before looking into the issue of online technology, I tried to understand the unique features of legal education, how legal education differs from other types of legal education. And some of my conclusions are here, and more of my conclusions are in this book, and I will be happy to leave a copy of this book for the library. So legal education is distinct because it goes beyond learning facts and logic. It involves active participation in a learning community to develop specific legal skills. It combines craft, judgment, and public responsibility, as well as the need to apply this in an ethical context. Unlike medical education, practical legal training in law begins usually after learning a law degree. Yes, some people have internships, but most of the time, real practice of law starts after people complete their legal education, which is different, for example, from medical education in most countries, where people have to intern or to have residency at hospitals for years before they're allowed to actually practice as doctors. The goal of education is usually to teach students to think like lawyers, to apply legal procedures to complex situations in a clear and strategic way. There are a number of challenges and global trends in legal education which I have observed. Legal education typically focuses on national law. However, globalization is making legal education more homogeneous across jurisdictions. International law firms are very active in big countries, also in small countries around the world. There are also consultancy firms, accountancy firms, which have a network around the world. And these firms, they impose, or not really impose, but in practice, they use very similar standards, very similar approaches. So that helps to unify approaches around the world as well. Also, there are international organizations, for example, the World Bank, the International Finance Corporation, which work on law reform issues, also helping to make law and legal services more homogeneous. But regardless of national differences, there is a similar expectation that lawyers must develop certain adaptive cognitive skills to keep up with evolving laws, practices, and market demands. Law is never static. It's always developing. Its interpretation is developing. Texts on the books, cases are developing. So it's not enough just to memorize laws and then apply those laws during their career. People need to have the so-called adaptive cognitive skills to cope with it. So this is an important feature of legal education, which makes it different, in my view, from other types of education. And in many jurisdictions, law was not a taught discipline, but it was a discipline which you could learn by being an apprentice, by working with a senior lawyer and then qualifying. Even in the UK, there was no need to have a formal degree in law until 1970s. And now in the UK, we see a revival of law qualification via the apprenticeship route. So in other words, you don't need to go to university necessarily. You can just work with a lawyer and then become a lawyer. So that highlights the need to have legal skills and to develop those legal skills. And I think India, from this perspective, is different from other countries, at least those countries with which I'm familiar. Because, for example, in the UK, you cannot go and practice law straight after your law degree. You need to have a training contract, you need to sit certain exams, and only then you can practice law. In the United States, also, it's not enough to have a law degree, you need to have a bar exam. And essentially, one of criticisms of legal education is that clients subsidize training of young lawyers, because young lawyers, when they come to a law firm, they do not know that much, and they have to be taught on the job. And at the same time, their time is billed to clients at rather high rates. So the clients are paying for their work, but their work is usually not of great quality, and more senior lawyers have to supervise them, have to direct them, which raises the question of why clients need to pay for education of young lawyers. And this problem exists in many jurisdictions because very often legal education is delivered in a didactic way, sort of lectures, then people read books, and then they tell what they read in books or heard at lectures without really having many opportunities to practice law as they study. If we look at various documents which regulate competence in legal education, so what you need to have in order to become a qualified lawyer, it appears that there is a convergence between various jurisdictions. There are certain cognitive skills, acquiring and using legal knowledge to solve real-world problems. There are certain integrative skills, using legal and factual data in legal reasoning. There are relational skills, communicating effectively, affective skills, demonstrating emotional awareness and ethical behavior. And there's also, I also observed that competence varies by jurisdiction, and different countries have different ways of assessing whether people have this competence. So this is based on my research of existing legal requirements, and I will talk later about my research, my interviews with experienced lawyers, what they think about the need to have specific skills and what specific skills they thought were important. The role of technology in law practice is rapidly increasing. So let's say 20 years ago, computers were barely used in legal practice other than for typing documents, printing documents. Now we increasingly see a reliance on legal databases, on information on screens rather than on paper. Also, the practice of courts and arbitration tribunals increasingly rely on e-discovery, e-filing. Very often, it's considered to be a bad practice to submit paper documents because it's considered to be bad for the environment. So many things are now submitted in the electronic format. Many dispute resolution methods moved completely to the online format. We have online litigation, online arbitration. Also, certain legal tasks have been moved from some jurisdictions to other jurisdictions as a result of outsourcing. Artificial intelligence is another topic which deserves not one, but many more books and more lectures. We also see the rise of various law tech startups. There was one recent study produced by Deloitte, which is a big consultancy firm, that over 114,000 jobs could be automated in the UK legal sector within the next 20 years. So we may see a situation when we have too many lawyers and not enough legal jobs, because many of those jobs will be replaced by artificial intelligence. Law teaching at the same time has not changed that much. I heard very impressive stories about what you are doing here at Symbiosis Law School, but in most universities around the world, law is taught in a very traditional way. Computers are used still primarily for typing, a bit for legal databases, but really people don't rely that much on technology. And in most countries, you see virtual learning environments. However, teaching remains didactic, detached from legal practice, and academia and the legal profession often remain as two different worlds. By the way, do you recognize who is on that picture? Barack Obama also used to be a law professor before moving into politics. So it's not enough, if you think about online legal education, it's not enough to just use computers and replicate exactly the same things which you do in the normal classroom. And there are several problems with it. There are barriers. There is lack of technical expertise and training. There's lack of time and incentives for academics to produce online courses, because it usually takes a lot of time to produce even a normal course and an in-person course. But if you have to record your lectures, if you want to make videos look professional, if you need to prepare quizzes, if you need to come up with new materials for the online format, it puts a lot of pressure on legal academics, and they're already, in many countries, they're quite stretched. They don't really have enough time to do research, to publish. So expecting them to come up with novel ideas for online legal education is also problematic. The effect of of technologies on learning has not been even. So in some countries there is more progress, in other countries there's less. Also within specific jurisdictions, some institutions are doing better than others. So we can see now that many more institutions are offering blended degrees. So some part of education is delivered in the online format, other things are delivered in person. And many are now offering entirely online degrees, mostly LL.M degrees, but also LL.B degrees. For example, the University of London LL.B can be obtained completely online. And some jurisdictions restrict the use of online technologies because they think that if you want to have a proper legal education, you need to come in person. You cannot do it in the online format. And when creating courses for the online format, it's important to remember that learning is not just about watching, reading, and memorizing. It's important to allow students to live and work in the real world environment. It requires formative legal assessments which go into thinking of students and changing and improving their cognitive skills. So when I mentioned that I was curious about theories of legal education, why legal academics were not very good with those theories, I thought that could play an important role by bridging sort of the worlds of education theory and the world of legal education. And there are a few people whom I want to mention who are considered to be very important in the area of theory of education. And I will mention some of their concepts, but I will not go into very technical details. I will try to make it as simple as possible so that you can remember it, and maybe it can be useful for your future learning, teaching, or even practicing law. So one of the most important people in the area of theory of education also happened to be born in Belarus, and probably I'm biased here, but his name is Lev Vygotsky, and he came up with a few concepts which are used in many areas of educational theory. One is that people learn from not only from the teacher, but also from the environment. There is spontaneous learning and there is scientific learning. And he did quite a lot of work trying to understand how kids learn, whether they learn, for example, from a teacher, or whether they learn more from other kids, from their peers. And he found that the learning from the teacher was as important, and sometimes was even more important. Sort of learning from other kids was even more important than learning from their peers. And I can tell myself, looking at my kids, that depending on in which country we are based, I spent some time in England and I spent some time in Poland because my wife is Polish. They also switch the languages which they use depending on the languages which are used by their peers. So in England, they would speak among themselves in English because they think that's sort of what people do. That's a cool thing to do. When we move to Poland, they tend to speak Polish. When we go to Belarusian circles, they tend to switch to Belarusian. And it's quite unusual, it's quite remarkable, because I'm not really instructing them. Okay, now in England, let's speak English. Now we go somewhere else, we speak other languages. And India has a variety of languages, so you probably may observe something similar here as well. So that concept applies not only for kids, but it also applies to adults, to education more generally. So the role of institutions is to create conditions to encourage students to engage in learning, not learning only from teachers, but also learning from other peers. And skills and knowledge must be learned in the context of social interaction through discovery, communication, and imitation. So these are important ways how people learn. And he came up with the concept of a zone of proximate development, which was then later used in other concepts by other practitioners and scholars of education. And the idea here is that you need to understand at which stage the student is currently based, how much the student knows and how much he needs to know, and whether you can switch or sort of jump from the current knowledge to new knowledge, or you need to sort of create additional layers of knowledge to help the student to transition to new knowledge. And a similar concept is a scaffolding, right? When you are building a new house, for example, you need to have scaffolding so that it's a temporary structure which helps to put your building materials together. And then once you can see that the house is stable, there are good materials, then you remove this scaffolding. So it's a similar idea here. You need to be to create these temporary structures, additional structures, not to jump from one area to another if there is no proper transition. Another scholar which influenced my research is Professor Diana Laurillard from UCL, who actually was my supervisor of my work in the area of legal education. She also worked for the UK government on online education, how to transition online education from more in-person education to online education in the UK. And she came up with a so-called conversational model, which allows teachers to split their educational activities into different modes. One is called acquisition, so it's when people are reading, listening, or watching, so it's a bit more passive way of learning. The second one is inquiry, so when you ask learners to find something, for example, find this case, and they have to go somewhere, find it, and prepare maybe something on the basis of that. Discussion is when people discuss things with their peers. Collaboration, putting together something as a result of joint work. Practice, so it can combine all those modes of teaching, for example, asking someone to produce an arbitration clause. So each of those modes is important, and to create a good course, it's useful to combine those different modes. Also in my research, I paid and here the idea is, so in other words, how you present information to learners. And it relates to texts, for example, how you structure a text in a book. Do you have it just paragraphs, or do you add pictures? Do you add subheadings? How you help to understand the structure of the text better. And it also applies in the context of creating videos for education. And here are some of the findings from here: how to understand structural levels without the text, how to focus attention of learners on what actually matters within the text, differences between deep learning and surface learning. Deep learning, you understand really the concept as a whole, its logic, and surface learning, you may understand the manifestations of this concept, but you may not understand deeper roots. And that's the last scholar whom I want to mention, textual and visual learning. Richard Mayer from the University of California in Berkeley, in Santa Barbara. He did quite a lot of work on online learning, on how to use multimedia products, how to avoid the so-called cognitive overload, how not to give too much information on the screen. Also, he wrote about dual channel learning. So when you use graphics, when you use text, when you use both, how you use spoken words in creating online courses, and so on. So what works in online legal education? So I not only talked did research in this, looking at books, but also I was trying to understand what people like and what people don't like in the context of online education. So I interviewed a number of people who took online courses, trying to understand their preferences, what they liked and what they didn't like. And here are some of the things which I found out that they liked. For example, they liked when experts were invited to classes. They liked when materials were presented as a conversation rather than a lecture. They liked mixing various video formats. They liked when video was presented as a coherent narrative, as a story. They also liked breaking videos into small chunks, allowing easy navigation between various parts of videos. So I decided to create an online course, and I will share later information about this online course, which is available online for anyone to take. I was trying to see how I could motivate students to continue with the course from the very beginning until the end. I was trying to see how I can increase the level of deep level learning, so not just watching and then forgetting, but really understanding the concepts which I was covering. I was trying to put the image argument synergies there so that images that were useful to learning. I was also focused on connecting law to practice by using case studies and by inviting practitioners. I will leave a leaflet about this course here. So essentially, I introduced the course by giving lectures on particular topics. And the course is about international investment law and dispute resolution. And then I talked to leading London-based practitioners, and I would usually go to their law firms or to their barristers' chambers so that to show what environment lawyers are working in. And then I came up with this model of contextualized active learning adaptive skills model, where I engaged practitioners in learning. I connected new knowledge in practical context to narratives. I created goal-oriented exercises with feedback. I elicited critical thinking to connect new knowledge to pre-existing knowledge. And I also focused on specific professional skills which lawyers needed. And in order to understand what professional skills lawyers needed, I interviewed senior practitioners in several jurisdictions, in the UK, in the United States, in Hong Kong, in Ukraine, and in the UAE, to identify what skills junior lawyers need beyond conventional legal education. As many of those people are partners at law firms, they were hiring young lawyers, and then they were also working with young lawyers. And there were certain trends which they observed, what issues they were experiencing when they were meeting those lawyers, and what problems those lawyers had. So I interviewed lawyers around the time of the COVID pandemic, also to understand how lawyers are trying to address those needs, and thinking how legal education more generally and online education can address those needs. And those people whom I interviewed, they came from various countries. There was someone from Uzbekistan, someone from Ukraine. There was one practitioner, I think he was from India originally, one from Israel, one from Russia. So various jurisdictions were covered there. And surprisingly, their findings were quite similar, although they were practicing in all parts of the world, in the United States, in Europe, in Asia, but they identified more or less the same skills. So there were 7 essential legal skills, which I describe in more detail in this book. The first one is focusing on the factual nuances that matter. And I'll talk about each of those skills in a moment. The second one is spotting critical legal issues. The third one is finding the relevant law. The fourth one is applying the relevant law to the legal issues, taking into account the context. The fifth one is identifying strengths and weaknesses of various positions. The sixth one is generating client-centric solutions. And the seventh skill is effectively presenting solutions. So let's have a look at skill number 1. So lawyers whom I interviewed thought that it was important to pay attention to small factual variations that can change the legal outcome, be it a case in court, in international arbitration, or maybe a different transactional document, I don't know, maybe a document related to a merger. They thought it was important to pay attention to detail because details very often matter. And detailed-oriented diligence with keeping in mind the strategic big picture was quite important for young lawyers, and this is something which they needed to master because they couldn't really take it from the school, from their university education. So they needed to identify which facts courts, tribunals will consider decisive. It was important for them to combine macro perspective, the overall strategy, with micro rigor. So looking at small issues, but remembering the bigger picture. Number two, spotting critical legal issues. There are usually so many legal issues which may arise out of a contract or out of a dispute. However, only a few legal issues actually matter. And these are the so-called essential legal issues. So young lawyers need to develop the ability to identify what the real issue actually is. And they need to do it early. Because if you identify wrong legal issues, then your research takes you in a different direction, which may not be helpful for your client and which may also be quite costly for your client because you may spend hours and hours looking at issues which do not actually matter. So they thought it was important to foresee potential issues which may arise during transactions or disputes and to recognize factual patterns that trigger specific legal norms. So you see there is a link between factual norms, or rather facts of the case, and the legal issues. And so there is always this interplay between facts and law. Number three, finding the relevant law. So senior lawyers valued the ability to find law, not to memorize it, because often you need to go into areas of law with which you're not particularly familiar. Sometimes you need to engage into comparative law exercising, looking at laws of different jurisdictions. So it was important to be able to find law. They didn't feel it was important to memorize law because for the reasons which I just discussed. Criticism, also I heard criticism of closed book exams because they thought that real practice requires research, not recall. But there are some problems with open books exams as well, particularly now in the age of AI, when people are tempted to use AI rather than to use their own legal thinking. Skill 4, applying law in the relevant context. So it was important to go beyond law in the books to commercial and practical realities. That also includes understanding client background, whether you work for industry, for a particular sector, for example, for a business there, for government, or you work, let's say, maybe as a human rights lawyer for an individual. So understanding the client's needs and the background was important. And the legal arguments must work in real-world scenarios, not just in theory. Skill number 5, identifying strengths and weaknesses of legal positions. Although lawyers often act as advocates, meaning that they were hired by one party to draft a particular contract or to represent a party in a dispute in court or in arbitration. However, lawyers need to have the ability to analyze legal issues objectively and being able to defend multiple viewpoints. So on the one hand, they need to have clear understanding of the case, and they objectively may think that this case is not particularly strong for their client. At the same time, they should be able to take a particular view, understanding these weaknesses and defend it. And this ability also is defined by the role of lawyers. If it's a lawyer representing a client, it requires one set of skills and understanding. If it's a judge, it's somewhat different. If it's a regulator, it's also different. If someone is an in-house lawyer or even a client without any law background, they may also have different take on what are the strengths and weaknesses of a particular legal position. Number 6, generating client-centric solutions. So it's important to be able to move from identifying legal issues to actually solve problems. And lawyers are expected to provide creative, strategic, and timely solutions. They also need to be able to mitigate risks and to protect client interests under pressure. So client-specific, client-centric solutions are important, not just abstract solutions, but those which address the needs of your client. And your client is not necessarily a business or a person who hired you. It can also be a government, a local authority. So essentially, those are entities or individuals for whom we work. And skill number 7, the final one, effectively presenting solutions. So essentially, it's about advocacy, being able to communicate solutions to clients clearly and persuasively. That includes written advocacy, and also that includes oral skills. Written advocacy involves drafting memos, pleadings, contracts, correspondence. Oral skills, framing arguments orally for tribunals, clients, regulators. It was important to avoid theoretical, overly theoretical writing, which students are usually expected to produce for their essays. They valued clarity, persuasiveness, professionalism, and also they valued situations when the writing is not too long. So it's important to be succinct in writing. And the common gap was that observed by senior lawyers was that new lawyers often lack strong advocacy and drafting skills. So these are the 7 important skills. And a few words on how these skills can be actually learned in the context of legal education, focusing on the factual nuances that matter. So students may be asked to explain what facts the court or tribunal is likely to consider when deciding a particular topic. Students may also be asked to identify the most critical facts that will determine the applicability of a specific legal norm. Number 2, spotting critical legal issues. Students can be asked to correctly identify as many as possible relevant legal issues in a given case, or even to identify irrelevant legal issues. But so as long as they understand that this is not so relevant to that particular case. Students may also be asked to distinguish and explain the reasons for let's say, why a particular legal issue is relevant or not relevant. Finding the relevant law, students may be asked to find online a domestic law, a treaty, or an academic article. They may also be asked to cite legal sources following a particular legal citation style, for example, or scholar. And very often students are struggling with following consistently one citation style, while it's very important in the context of practicing law to be able to do it. Applying law in the relevant context, design narratives and questions, focusing students' attention on a particular context, commercial context, cultural context, and maybe even political context, and identify the elements of the context which will affect their answers. Identifying strengths and weaknesses of positions, it's fairly straightforward. For example, students may be asked to prepare arguments favoring only one side and identify positions, strengths and weaknesses of positions of each party engaged in a dispute. Generating client-centric solutions, different theories to justify or resist a particular claim given the client's needs, explaining the needs of different approaches and how to mitigate them. And finally, advocacy skills, draft answers to questions in a clear professional language guided by an example, letter, memorandum, or claim, prepare an oral presentation addressing a particular legal issues for a specific audience. And as I understand, this school, you have quite a good tradition of moot courts. And that's a very good way to be able or to become a better advocate. I also did quite a lot of moot coursing when I was a student. My focus was on public international law, and we went to Jessup moot court in Washington, D.C., to international rounds that we didn't win, but it was still a great experience, which I cherish, and I think it was one of the most interesting experiences and was the most rewarding experiences of my when I was doing my first law degree. So a few words about the courses which I mentioned, and then I will be happy to take a few questions. So the course International Investment Law and Dispute Resolution, you can find it online, and there also there will be a few vouchers. You can take a picture. There is a discount code here. Also, we do quite a lot within the framework of Arbitration Lab. It's a Swiss-English initiative to promote international arbitration, and we organize a Basel Winter Arbitration School in Switzerland every winter in February, and London Summer Arbitration School in London. And the dates are already decided for our Basel Winter Arbitration School. And actually, I met Akash before he went to Oxford. It was in Basel in Switzerland. He was one of applicants from India who got into our winter arbitration school. And I think that experience, and then he did some other work with us, that experience helped him to land into the doctoral program at Oxford. So the winter arbitration school, actually, I think the largest cohort of participants which we have are not from Switzerland, they're not from the UK, they're from India. So there's a great demand for comparative and international legal education, and we have made okay, you have it here, but it doesn't change. And the London Summer Arbitration School, they are not duplicates, because we look at different arbitration frameworks, different skills at each school, and those people who complete both the winter school and the summer school, regardless of the order, qualify for diploma in international arbitration. I think Akash did it. Malhar, who is here, he also did a diploma in international arbitration. And we also help people to network with law firms and also have fun in those cities. So here's the book, Educating Lawyers in the Digital Age. It is available online, and I'm happy to give one copy of the book for the library here. You can find this one. And in addition, we also organize shorter courses. For instance, in November, this is Arbitration Lab website. In November, on the 12th of November, we organized a so-called career readiness workshop, where we bring together people in London and also online to talk about job seeking skills, how to write a cover letter, how to formulate your CV, how to conduct yourself at interviews. And although the focus is primarily on the London market, these skills can be useful beyond London, in Singapore, in Delhi, in Mumbai, because international arbitration is very similar across jurisdictions. We also have an online course on careers in international arbitration. So with that, let me thank you for your attention, and I will be happy to answer your questions. There will be some materials left here on this table after the talk. So are there any questions? Yes, I can see a number of questions. How are we going to do it? Maybe we can take questions in batches of 3, and then I'll address 3, and then we'll move to the next 3.
Good afternoon, Dr. Yarik. So you mentioned in your lecture regarding Wikitzki, and I was wondering that you talked about learning from peers in that slide. How do you incorporate that in within legal education system? Because as we see in India and in Southeast Asia, the system is primarily didactic, and the teachers usually teach us. So how do you propose that we harmonize this with legal education?
Thank you. So let's have two more questions.
So just one very simple question. So you talked a lot about analyzing arguments and making arguments, right? I just had a question is, young law students, when we look at a particular legal argument, how do we weigh its benefits and like strengths and weaknesses? How do we weigh it? That's the question. Thank you.
Thank you very much, Dr. Yarik, for the insightful lecture. Building on your discussion of adaptability and problem solving, I would like to ask, in generating practical solutions for clients, what role does creativity play in addressing both current and potential future risks? And how does this differ between transactional work and dispute resolution?
Thank you. Yeah, excellent questions. When it comes to learning from peers, there are various ways how learning from peers can be organized. The most simple way is perhaps to ask or to split people into groups and have a group exercise. What I often like to do is I give a scenario, so a dispute in there between a foreign investor and the state. And I ask one group of students to think about arguments favoring the investor, and the other side and the other group to think about arguments favoring the state. And the idea is that when students discuss various arguments, they also learn from each other. And also students may be asked to put together a joint memorandum on something. That's also learning from peers. When you participate in moot court competitions, you definitely learn from other people who are on the same team with you. So it's not only you're learning from the coaches, you're also learning from other people who are with you. What else? Learning from peers can also take place in peer reviewing exercises. So, for example, you ask everyone to write an essay, but instead of giving those essays to the teacher for marking, you ask someone else or another student to look at this essay and to give feedback. That's also a way to learn from others, from peers. But at the same time, it's important to have some engagement from the instructor, because you don't want wrong teaching to happen. Someone maybe doesn't know the material well, but he's very confident or she's very confident and say, "Oh, this is the right way." So it's still, there is an important role for teacher to play. When it comes to strengths and arguments for strengths and weaknesses of various arguments, when we are in the context of dispute resolution, the easy way to give examples of strengths and strong and weak positions is to look at a long decision of, for example, of a Supreme Court, where they discuss in detail each argument of each party. And students may be asked to say, okay, can you see which arguments the court thought were strong and which arguments they were weak, or they were actually, it was counterproductive to make these arguments. So I think this is quite useful. Also, if you have someone who is more experienced, be it a teacher or maybe a more senior student, you can ask this person to give feedback and to give some tips and suggestions on how to identify based on their own experience. Because sometimes you need to base your judgment not on books or on cases, but on just your experience when you have years practicing a particular topic or teaching a particular topic. That could be a source. When it comes to risks, assessing risks in the context of transactional work or dispute resolution work, in a way, it's similar, but the risks are different at the same time. So, for instance, when you think about risks in the context of transactional work, the main risks come from the other side, from adversaries, but also from regulators. You want to make sure that your contract is compliant with the relevant laws, that it cannot be then unenforceable for one reason or another. In the context of dispute resolution, the risks usually come from exposing some weaknesses to the other side. And then the other side can either undermine it in court, or may, for example, in the context of international arbitration, may try to annul an arbitration award or challenge enforcement of arbitration awards. But the risks are not just legal, they may also be business risks. So, for example, whether someone will be able to pay, let's say if someone loses in arbitration or litigation, can you actually collect money or not? Or you will just spend lots of money on winning a case and then you cannot enforce it. Or they can be also political. Let's say in the context of investor-state arbitration, very often political risks come into play, public policy issues, which may interfere with legal issues. Do we have time for 3 more questions? One more round of questions? Okay, so let's have 3 more questions.
Good afternoon. Given the vast and evolving legal resources, how can aspiring lawyers efficiently locate the most pertinent laws and precedents, especially when dealing with unfamiliar jurisdictions of international matter?
Good afternoon, Professor Yarik. Thank you so much for a really insightful session. I just wanted to, so I was quite intrigued when you talked about adaptation in addition to interpretation as key lawyering skills, right? And slightly technical, but I was reminded of the legal transplant principle by historian Alan Watson. So I just wanted to understand, in your opinion, when you talk about legal transplantation with respect to, let's say, a foreign law or a public international law being incorporated into, say, domestic law contexts, like we've seen in India, in Sri Lanka with respect to the Geneva Conventions and so on, do you think the issues that arise, like the social dysfunction or legal dysfunction that arises out of that incorporation, is that an issue of, say, interpretation on part of the lawyers, or just like a structural loophole when it comes to implementing the law? And as lawyers, how do we deal with that?
Yeah.
Good afternoon, sir. I have a question. Now, as a law student, when we talk about a lot of legal issues, when we study legal problem as in, we find a lot of plethora of legal issues which are there, right? So we are able to deal with it at domestic level. But when we talk about international level, suppose maybe public international law, how do we actually try to find out these legal issues because these are such extensive issues which are difficult to find out? So can you suggest some ways that how can we do it at such international level?
Thank you. Thank you. Very good questions. The first one, legal resources, legal information, how to find it. In practice, increasingly these days, people tend to focus on using AI as the first step, artificial intelligence, to address a specific issue. But when we're doing it, I think it's useful to do it. We need to remember that AI is not objective. It may try to appear objective and balanced and so on, but there are biases built into each system. Nothing can be completely objective. So we need to be very careful with using AI instruments. And recently, In the UK, there were a few scandals when lawyers relied in their submissions on cases which did not exist. The so-called hallucinations, right? AI can come up with completely fictional cases, completely fictional scenarios, and then lawyers didn't do their work properly. They would just copy paste, and then they would send it to a court, and that's a huge embarrassment to any lawyer. So you really need to be careful with it. And if you use AI, then always ask to give the source, and then go to the source and check where this information comes from. And then you can go, let's say, to the official website, or you can try to double check in other sources. So that's one way. Another way is to usually a starting point for any legal issue is to look at a textbook on a particular topic. If it's a criminal law topic or commercial law topic, just go to a leading textbook and see what this textbook is saying. And usually that textbook would have references to relevant cases, relevant articles, and so on. So that's fairly easy. When you deal with unfamiliar legal systems, it's important to be even more cautious, because you may think that another legal system is similar to yours, but there may be hidden issues which may come out later. And it's always, well, maybe for purpose of student essay, you don't need to engage a foreign law expert. But when you work in the real life, it's always important to have someone who is qualified to practice law in that particular jurisdiction. The second question was about adaptive legal skills and legal transplants. My research didn't really focus on legal transplants, but I understand the concept. And so the idea is that you take laws from one jurisdiction, and then you are trying to almost copy paste those laws into another jurisdiction. And although, as I mentioned earlier, as a result of globalization, legal systems around the world become increasingly similar to each other. There are still important differences which remain. And you cannot, for example, just copy paste I don't know, a law from Norway and then hope that the same law will work in India or in Norway or in Australia, because there are different legal systems, different cultural, different law enforcement dynamics which need to be taken into account. But when you deal with foreign law or with comparative law, it's always good to have a starting point, your domestic legal system, because this is the system with which you are familiar. And you should assume probably that other legal systems are similar, but you should not take it for granted. It's important to go beyond this initial assumption because of these differences between jurisdictions. And the last question, international public law, how to research it. Well, public international law is different from domestic law. It has different sources of law, somewhat different ways to interpret it. And now there are increasingly, there's an increasing number of databases dealing with public international law. You can have access to decisions of various international courts and tribunals. For example, if you look at pure public international law, you can go to the websites of the International Court of Justice, of the Permanent Court of Arbitration. There are different areas of arbitration, for example, where you can find a wealth of cases, for example, sports arbitration or World Intellectual Property Organization arbitration. So you can go to cases. There is a problem with sometimes finding a good textbook about a particular area of law. For instance, now we are co-editing a book with Professor Patrick from the University of Basel called The Anatomy of International Arbitration. And we found out that, for example, there are no books on commodities arbitration, and the books which cover, for example, intellectual property arbitration are quite limited in scope. So you need to find articles, you need to find cases, you need to do your own research in this field. But now I think it's becoming increasingly easy, and some of those books and articles are also available in free access. You don't even need to have a subscription to a paid database. So these are my answers. I don't know how much time we still have? Yeah, I think we're done, yeah. Yeah, well, thanks again for your attention, and there will be some materials here, and I'll leave the book for the library.
Thank you very much, sir, for that insightful and thought-provoking lecture. Your words have given us valuable perspectives on the skills required to grow as successful lawyers and have encouraged us to think about how we can develop them in our journeys. To conclude today's session, I now invite Dr. Aprajita Mohanty, Associate Professor and Deputy Director, Symbiosis Law School, Pune, to kindly deliver the vote of thanks. Please.
Thank you. On behalf of Dean and Director Dr. Shashikala Gurpur, I thank Dr. Yarik for delivering a very insightful talk on 7 key legal skills for success as a lawyer and how to master them. Thank you, Dr. Yarik, very much. For bringing to the fore the fact that lawyers must develop adaptive and cognitive skills for greater relevance and efficacy so that they can keep pace with the changing and ever-evolving demands of time and of the market. I thank Dr. Gurpur for bringing learning beyond classroom. It's your effort and foresight that our students have been exposed to these 7 key legal skills right from the first year itself by way of ensuring clinical legal education training for all, for all, which leads to the novice moot court. I thank the directors of 3 sister law schools, Dr. Ravandre sir, Dr. Sunil George sir, and Dr. Sukhvinder sir for attending the session. And I thank the faculty and the students of Symbiosis Law School Pune and all other 3 sister law schools for attending the session. And I thank the organizers of the event. With this, I thank one and thank all. So I will stand it over to Gurpur Madam, sir. Thank you. I'll just give it. Like this.
Thank you, ma'am. With this, we formally bring today's guest lecture, Faculty Development Program, to a close. We wish you all a pleasant day ahead. Thank you once again. I request all the students to be kindly seated until the dignitaries have exited the dais.
Hi, excuse me, I'm Malhar. I'm an associate with Professor Yarik. If you guys want to leave for lunch, you can. But some of you want to stay for the website. Like, I'll just show you how to register for the programs so that it's easier for you guys to register. So if you're free to leave, but if you guys are interested, you can wait and stay. So this is our career readiness program in London. So I work with Professor Yarik in London on this program. So we've partnered up with Step2 International LLP, which is an international arbitration firm in London. So you guys can open up this website and register. There's a link if you just scroll down. And so we're closing early bird registrations on 30th of September. So you guys might want to be quick. It's 2 weeks until then. So we're charging. So I was given to understand that you guys might have some engagements in the middle of November. So we've also kept it open as a hybrid course. So you guys can also do it online. We're charging £129 for online, and we can give group discounts to SLSP as well. So I can speak to Professor Gurpur and other professors about it, but then I just want to show you how to sort of navigate the website and all. I think it's one of a kind to bridge theory and practice. Professor Yarik already mentioned. So yeah, and you can check out the other programs in our website as well. And you can speak to me after the program if need be. Thank you so much for your patience and attention.